On January 12, 2026, Joshua Sanchez Lopez was arrested in Las Vegas, Nevada, on charges of grand larceny of a motor vehicle. Law enforcement officials identified the incident as the defendant's 35th arrest in the jurisdiction. On the next day, Judge Eric Goodman set bail at $25,000. However, after the defendant posted bond, the Las Vegas Metropolitan Police Department, also known as LVMPD, refused to process his release. On January 29th, the police formally refused to release Mr. Lopez, leading Judge Goodman to threaten contempt charges against the department and Clark County Sheriff Kevin McMahill. On March 9th, Metro Police responded by filing a petition with the Nevada Supreme Court, seeking to prevent the enforcement of the judge's order, arguing it violates the sheriff's statutory duties. The department's position was supported on March 13th, when District Court Judge Erica Mendoza issued a ruling in a separate matter. Judge Mendoza affirmed that Metro and the sheriff have the administrative authority to set their own standards to refuse any defendant they deem an unreasonable risk to public safety. Mr. Lopez attorney David Westbrook argued that Sheriff McMahill is overstepping his jurisdiction, where these patterns of response from Metro Police Department were a violation of his client's due process rights. Mr. Westbrook argued that this conduct violates the constitutional right to individual liberty. On March 19, 2026, a procedural conflict erupted during a hearing regarding the Las Vegas Metropolitan Police Department's refusal to release Mr. Lopez, leading to an exchange between Judge Goodman, Mr. Westbrook, and Metro Police Department's attorneys Michael Dickerson and Lydia Anderson.
Mr. Westbrook, I made a motion you want to make.
I do, Your Honor. As I indicated to the court yesterday, via email with all parties on the email, I'm requesting a continuance of today's proceedings, and the reason for that is simple. About 36 hours ago, I don't know, my timeline is a little tough because I just got off an airplane from Oklahoma. About 36 hours ago, Metro filed a new supplemental briefing. I haven't had a chance to even read it, much less respond to it, and I want to file a response in writing, which I think is our right. All that it takes for continuance is good cause, and their late filing is my good cause. There's other reasons that I can present, but I want to start with that.
But that is simply the order that Judge Mendoza actually had. We actually have a written order now.
Well, we have a written order that in no way binds this court, number one, and number two, I need to actually address what the power of that order is. And here's the thing, this came up before, and I'm actually surprised that Metro wouldn't just simply agree to the continuance in this case, since they've been asking for stays nonstop in all these cases. But here's the issue. When we were in front of Judge Mendoza, Metro filed their brief in that case, a 25-page brief with a bunch of exhibits, at 5:50 p.m. the day before the hearing. It wasn't served on us properly. I didn't get it until we appeared for oral argument and it was handed to me. I got somewhere between 20 and 40 minutes to read it. And we were in a situation there where I could not ask for a continuance to fully brief the issue, because my client had been ordered by the court onto medium-level house arrest. House arrest refused, told the judge, we're not following your order, and said, but you can release him on house arrest. So he was pumped up to high-level house arrest in that case. The problem is that was going to interfere with his job, and he was afraid of losing his job. So I had to go forward then. Also, the sentencing was right around the corner in that case, and it would have damaged my client. I believe that was the case I'm thinking of. It would have damaged my client to have the sentencing continue, just because I'm briefing this issue. So I could not, in that situation, ask for a continuance to file a written motion. I got it with about 20 to 40 minutes to read it, and I went up there and argued this brand new issue that I had never seen before, with arguments I had never seen before, on a motion that I was never even served with, and did my best in front of the court. Now, subsequently, I asked the court for an opportunity to actually brief the case, and Metro opposed. So their argument was, you should have asked to continue it, and you should have asked to brief it. You didn't do that, and so we're going to oppose any opportunity to brief it now.
To the court. You talk about my court.
Oh, sorry, Judge Mendoza is what I'm talking about.
Okay.
Yeah, I'm talking about the other case, Judge Mendoza.
I need to keep it straight.
Yeah, I am. So I asked Judge Mendoza for an opportunity to brief it, and I filed a proffer after the hearing of arguments that I would have made had I not been shut down. There was also a lot of oral argument I was trying to make in that case that I was shut down on, and Judge Mendoza wouldn't hear. So I was denied the opportunity to brief it in front of Judge Mendoza, and their position was you should have asked for a continuance. Well, now we're in a similar situation today. They just filed something to the court. I have a right to reply in writing, and I'm asking for a continuance because my client's not in a situation where my request for a continuance will hurt him. So,
This case is in front of the Nevada Supreme Court at this point, is it?
yes, it is.
With 3 other cases?
Yes.
And
3 or
it's
4.
being argued in front of the Supreme Court.
It is being argued in front of the Supreme Court. However, we've all agreed that the contempt issue is not moved.
But that's what happened with Mendoza. And she's in higher court, she discharged.
Right, but she's not, she, first of all, again, I need to address that in writing. If I'm not allowed a continuance to file a written brief, then I'm in the same situation here as I was in front of Judge Mendoza, and the court would be in a situation where you don't have the full information of the full law in order to hear this argument. And we want to avoid summary decisions. I mean, part of our complaint about what Metro is doing on Mr. Dickerson's advice is that they're making summary decisions behind closed doors, where nobody is present, there are no checks and balances, they don't even have a consistent format for rejecting or accepting people to their program, they won't share the information with us, and we're not allowed to appear and present our case. And what they want to do is turn courtrooms into the little back rooms where they make their decisions.
Is this the motion to continue, Your Honor?
Yes, it is.
Yeah. What is this nonsense?
It's my motion. Okay. Well, I appreciate you calling it nonsense, Mr. Dickerson. I know you think due process is nonsense, but I happen to disagree with
I
you.
just think that your diatribe here is nonsense.
Thank you.
Mr. Westbrook formally requested a continuance so he could have time to deal with the briefs filed by the police department 36 hours before the hearing. Under the Nevada Revised Statutes, 178.472, an 8th Judicial District Court rule governs the postponement of legal proceedings and the timing of motion practice. Mr. Westbrook affirmed it was statutorily and constitutionally insufficient to allow for a meaningful review or a formal response. Mr. Westbrook argued that Metro was attempting to leverage those past summary decisions to prevent him from filing written responses in the current case, effectively making legal determinations without transparency or procedural due process. Mr. Westbrook challenged what he labeled a functional veto, arguing that such an action constitutes a violation of the separation of powers doctrine under Article 3, Section 1 of the Nevada Constitution. This occurs when an executive agency effectively overrides a judicial mandate by refusing to provide the administrative services, like electronic monitoring, required for a defendant's release. He maintained that the judiciary holds the inherent authority to set bail conditions, and an executive refusal to comply is an unconstitutional encroachment on judicial independence. Under the 14th Amendment to the U.S. Constitution, the government must respect all legal rights owed to a person, ensuring a fair and neutral procedure before any deprivation of liberty occurs. When Mr. Dickerson dismissed these arguments as nonsense, it led to a contentious exchange regarding the fundamental fairness of the proceedings and the Sixth Amendment guarantee of effective assistance of counsel, which Mr. Westbrook argued was compromised by the state's failure to provide timely notice regarding the legal basis for the continued detention of Mr. Lopez.
Like every other lower court, I follow the upper courts. Whatever the higher courts tell me to do, whatever they're doing, I'm gonna follow what they're doing. I mean, she did discharge it. I mean, it took a while to get a written this wasn't filed until the 13th of this month. That was given to me by Metro, but she could discharge it up there. This is not the exact same issue, but it's adjacent to the issue in front of me. I mean, it's all in the same ballpark. Given that's what Judge Mendoza did, and she's a district court judge, I'm a justice court judge. I mean, I'm just going to dismiss the case down here. I'm going to discharge the order the same way that Mendoza did.
Okay. Well, we obviously object to that.
Oh yeah, of course.
They've agreed.
You objected up there, you're going to object down here.
And look, this is what they're trying to do. They keep sending me.
But you'll be in front of the Supreme Court.
I will be in front of
the decision.
I will be in front of the Supreme Court, but here's the issue.
Yeah.
They keep asking for first of all, Judge Mendoza's order in that case does not bind you in this case in any way, shape, or form. Okay, so let's put that out front right away. And you know who likes to make that argument? Metro. As you might recall, we had an issue a few years ago regarding the subpoena power of defense attorneys, where we had district courts saying that we have subpoena power, and Metro was arguing throughout that those district courts didn't make an order in this case, so therefore they don't apply. Now they're arguing the opposite. They like to argue both sides. Heads I win, tails you lose. That's not what the law allows.
Your Honor, we could stand here and go tit for tat all day long about these allegations.
I am
and
following
making-
the written.
Yeah, the
I have the
court has made its
transcript. I have the
order.
transcript. It's destructive. But now the actual written order.
Yes.
That kind of controls down here. Her order kind of controls down here. If anybody wants to make records, you're welcome to make records. But given what Judge Mendoza ruled, or her order, I'm discharging this. So if anybody wants to make a record, you're welcome to. But yeah, discharging it.
Well, Your Honor, I'm in the middle of the record right now.
Okay.
Okay. And this is my record.
Okay.
That is a violation of due process.
Okay.
They have agreed that the issue of contempt is not moot. Your Honor, you're the person who decides whether whether Metro committed contempt in regards to your order.
Hold on, I have to find that in bad faith. I have to find that in bad faith that they had no basis for what they did. They had a parallel action up in front of Mendoza, Judge Mendoza. It's not this issue, but it's basically the same issue. So when they denied my order, at least they had a basis, because there, at least at that point there was the transcript. So that a basis, it would have been as nice as an actual order, but at least they had a basis for denying it. And I can't find that they acted in bad faith. I mean, the order came, so I can't find the order they acted in bad faith. So, I mean, I'm discharging this.
Well,
I'm
Your
not
Honor-
going to find any kind of contempt.
Thank you,
Your Honor, you
Thank Your
can
Honor, because
find,
that is a discretionary decision of this court.
I know, I read the order for
Your Honor,
Okay.
do you believe they acted in bad faith? Because it sounds to me like the issue that you actually do believe they acted in bad faith, but you feel restricted by an order from a district court that has not made the order in your case. I mean, that's why we're here. It's so that the court can actually rule on this.
They had a transcript where it looked like Judge Mendoza was going to rule this way, the way she ruled.
Okay.
Judge Goodman discharged the order to show cause, concluding that he could not find evidence of bad faith on the part of Metro. An order to show cause is a formal demand for a party to justify why they should not be held in contempt under Nevada law for failing to follow a court order. The judge determined that because Metro was acting based on a plausible interpretation of Nevada revised statute, their actions did not constitute the willful or dishonest intent required for a finding of contempt. Metro Police Department contends that this statutory grant of power allows them to deny a judge's request if they deem a defendant a threat to public safety, asserting that the judicial branch cannot compel the performance of a discretionary executive function. Mr. Westbrook objected to this interpretation and challenged the recent ruling by Judge Mendoza that supported Metro's position, arguing that findings from a co-equal department do not constitute binding precedent on this court. Mr. Westbrook argued that allowing the police to veto a release order constitutes an unconstitutional infringement upon the inherent judicial power to set conditions of pretrial release.
And that's the way she ruled.
And she ruled without even giving me the opportunity to fully brief it.
You're in front of the Nevada Supreme Court.
I am in front of the Nevada Supreme Court. But Your Honor, before you go on, I have to talk to you about my full record, and I have to give you the public interest angle on this as well as everything else. I've already given the legal angle, and I object to it. I think this is a violation of due process. But let's look at what's actually happening here. Metro keeps filing requests for us to agree to a stay of all proceedings on this until the Supreme Court has ruled. And my response to all of their requests to stay has been exactly the same. I will gladly agree to a stay of all contempt proceedings in all lower courts if Metro will agree to stop committing acts of contempt. They will not agree to that. They've created this completely false narrative in the media, which is designed to stoke fear. Mr. Dickerson is very good at going to the media and telling people to be scared of defendants, when what we should actually be scared of is this star chamber backroom denial of people's rights without any due process. That's what we should be scared of. And he knows he's wrong on the law. So he's trying to go out there.
That is blatant bait.
I get to
This
talk.
isn't a record, Your
I get to
Honor.
talk,
This
and then you get to talk.
grandstanding.
And an ad hominem attack, Your Honor. This is not so.
I want you to go back a few sentences and remember what you just said about me. Okay, so the point is, I think he knows he's wrong in the law, and so instead of fighting it in a courtroom, like today, he's fighting it out in the media, and he's trying to use fear. I know that the court's probably gotten phone calls from people with threats. I've gotten phone calls from people with threats. And that's an atmosphere that was created by Mr. Dickerson in the media.
And
Because
to
he
that
knows...
Hold on a second. And no offense to the media. I don't care about the media. My
I'm
dad has never cared about the media.
Yeah.
I don't really worry about death threats. It doesn't bother me
No.
whatsoever. What I worry about, what I care about, is what the district court does. Because we're the lower court.
I'm glad the media is here, Your Honor, because they're the fourth estate, and they're the ones who are going to actually show what's happening behind these closed doors. So I'm very glad the media is here, but the way Mr. Dickerson
And
is
they're
using the
welcome
media...
to. They're absolutely
Right.
welcome to. They're in here filming this. They're absolutely welcome to do whatever
Absolutely.
they want. They'll do whatever they want.
Then we're in
But what I
agreement.
care about at the end of the day is what did Judge Mendoza do?
Yes, and I am asking you for the opportunity, because if you don't give me this opportunity, then your decision is now summary, just like Judge Mendoza's decision was summary. I'm asking for the opportunity to brief this issue that was just handed to me by these guys 36 hours ago. I'm
But
asking you to brief
it was
it.
something you knew was coming for weeks, because you were there for the argument in front of Mendoza. And she pointed to the fact that she was likely to rule exactly how she ruled.
She wrote a 17-page order, which I haven't been able to brief, Your Honor. Okay, listen, Mr. Dickerson's in a great position because Metro has the ability to go and hire outside counsel to go do their work. All right? These are two private attorneys who are very good at their jobs that Metro is able to use taxpayer money to hire. I am a public defender,
Yes.
and
You're
unfortunately,
very good at your job.
thank you very much.
You're very good at your job.
But I don't get to hire anybody outside. I've got a team of other public defenders who also have other jobs to do that are helping me, on this case. But I don't get to hire outside counsel to do all this work. I was just in Oklahoma doing death penalty work that is extremely important as I'm trying to save a life. And I come back here to this and I ask for a reasonable continuance to brief the very issue you're currently ruling on. And if you rule on it without giving me the opportunity to brief it, then it's another denial of due process and it's a summary order. And my question is, what is the harm in letting me present my case? And I'll tell you what the harm is. They're wrong on the law. And so they want to try to debate this case in the court of public opinion. Because in a court of law, they're going to lose. So they're trying to shut me up. It's like, pay no attention to that man behind the curtain. When someone says that, you pull back the curtain. And if you do, you'll find Mr. Dickerson there saying, please, dear God, don't listen to what he's saying because
No, listen to
you'll
it.
agree with it.
It has no basis in law. He hasn't made any legal argument. That's
Sure.
the bottom line. He
I
has
have.
nothing.
Do you disagree that
No,
if I have
you
good
don't
cause
need to
for
hear this
continuance?
in the Nevada Supreme Court. You know where it is right now, the Nevada Supreme Court.
That's right.
You
Thank
know
you.
what I'm going to listen to? You know what I'm going to listen to at the end of the day is the Nevada Supreme Court.
Oh, we all are, Your Honor. That's their job.
Yeah.
But listen, in
And
the
I'm not going to
meantime,
overturn a district court judge.
they're going to continue to violate clients' rights, and then they're going to go into a courtroom every single time I do a motion for an order to show cause, and they're going to say you can't rule on this judge because Judge Mendoza, based on one-sided briefing and a partial argument in an ambush hearing, ruled in our favor.
All of those comments that he's making are belied by the wording of the order, which he apparently has not read.
Right.
Because
Oh.
the Judge Mendoza addresses each and every one of these contentions that he's making. For example, Your Honor, he filed a giant proffer after she ruled from the bench, discharging the order to show cause, with all of the arguments that he wanted to make in response to our brief. And she accepted it and considered it, and that's why it took over a month for us to get that written order. So all of these things, all of these issues that he's raising were addressed by Judge Mendoza before she wrote that order.
Mr. Westbrook claimed that the Metro Police Department is constructing a false narrative to stoke public fear, effectively attempting to litigate the matter in the media because they cannot prevail in the court of law. He characterized this media-centric strategy as a tactical distraction from the department's denial of procedural and substantive due process. He maintained that the true concern is Metro's decision-making process, where the sheriff unilaterally rejects court-ordered releases behind closed doors in an extrajudicial exercise of power without judicial oversight. By contrast, Mr. Dickerson countered that these defense arguments were already addressed in Judge Mendoza's previous ruling and are functionally barred by the doctrine of law of the case. Judge Goodman agreed with Mr. Dickerson, clarifying that the court's primary focus remains on procedural consistency with the district court's ruling.
So I'm sorry, I think they're saying that I'm wrong on the law and that I'm wrong on what the order is. And what I'm saying is, I can show you that I'm right on the law and right on the order if I'm allowed to file a brief that's responsive to the pleading they filed less than 36 hours ago. So we both agree
No.
that I haven't made my point very clearly and I haven't cited to the law. So I'm asking to do that and they're saying don't let him do that and you're agreeing with them. That's a problem.
Your motion for continuance is denied.
Okay.
If you want to make any kind of record, you're welcome to make a record now that he made his
Is the
record.
finding that I don't have good cause or is the finding that you think you can't give me a continuance because of Judge Mendoza? I needed to know exactly why.
I was waiting to see what Judge Mendoza did. It's the exact same, I mean, not the exact same issue, but like I said, it's the same ballpark as what has happened in my department. All this is now in the Supreme Court. The Supreme Court will hear this. So save all your energy and all of this for the Supreme Court.
Well, I don't have to save my energy, Judge. I got plenty.
Anything?
No, Your Honor, thank you.
We object under the due process clause, under the rule that allow me to file responses to motions that are filed by counsel.
We didn't file a motion, Your Honor. We filed a notice of supplemental authority, simply giving the court the written order that was in the transcript that we provided to you, and which has been part of the briefing all along.
Okay, it hasn't been because it's a new order. That's just not right.
Okay.
Haven't been given an opportunity to
Case is
respond.
discharged.
Thank you.
Your Honor, thank you.
You know what, we need to figure out the underlying case. Now that all this has happened, where's oh my gosh. This creates a quagmire.
Yeah. Well, when Metro violates the law, and it does create a quagmire.
Yeah, Metro, you're free to leave.
Thank you, Your Honor.
Thank you, Your Honor.
The underlying case.
Get slandered some more.
Don't talk to me about slander.
Judge Goodman denied Mr. Westbrook's motion for continuance. Mr. Westbrook reinforced that the denial of a continuance in this matter constitutes a violation of the procedural due process guarantees of the 14th Amendment and Article 1, Section 8 of the Nevada Constitution, arguing that the defense was deprived of a meaningful opportunity to be heard regarding the government's latest filings. Judge Goodman stated that because the constitutional questions are virtually identical to those currently pending appellate review by the Nevada Supreme Court, all parties should direct their attention and resources toward that higher venue rather than rehashing the debate in Justice Court. On the same day, Mr. Lopez was remanded in custody. Judge Goodman, who had previously threatened to arrest Sheriff Kevin McMahill for contempt of court for ignoring his release order, backed down during the hearing. He decided not to punish the Metro Police Department, citing the absence of bad faith and the fact that the dispute over the authority of electronic monitoring was being reviewed by the Nevada Supreme Court. This proceeding highlights a fundamental tension in the legal system, the balance between judicial authority and the administrative discretion of law enforcement. Judge Goodman asserted his power to issue and enforce release orders in order to maintain control over the court's jurisdiction and ensure that judicial mandates are followed. In contrast, Mr. Westbrook resisted on the grounds that his obligations to his client's liberty required him to challenge the Las Vegas Metropolitan Police Department's refusal to process those orders, which he characterized as a violation of due process. The clash also underscores why procedural transparency and timely disclosure are critical to the adversarial process. The practice of filing late supplemental briefs, even if they contain relevant legal precedent like Judge Mendoza's order, creates the appearance that one party is attempting to gain a strategic advantage by ambushing the opposition. By limiting the defense's time to respond, these tactics risk causing the court to make summary decisions without a full, balanced presentation of the law. Together, the events in this case illustrate how the legal system must constantly balance the authority of the bench, the duties of the police department, and the procedural safeguards designed to ensure both fairness and the appearance of fairness for the defendant. Now, let us know if there is a case you would like us to explore in the comments below. In the first comment, we will leave the interview that Mr. Westbrook did after the hearing for those who want to see his point of view. Thank you for watching, and don't forget to like and subscribe for more videos.